Supreme Court declines to hear Chicago area assault rifle ban. The Supreme Court will not consider a challenge to an affluent Chicago suburb's ban on semi-automatic rifles that accept large-capacity magazines, the court announced Monday. The High Court declined to hear the challenge to Highland Park, Illinois' ban on so-called assault weapons and large-capacity magazines. The ban was upheld by the U.S. Court of Appeals for the Seventh Circuit. The city of Highland Park bans the sale or possession of semi-automatic guns that have folding, collapsing, or thumbhole stocks, muzzle compensators, pistol grips, or pistol grips with a stock attached. Critics of assault rifle bans argue that these features are cosmetic and do not enhance the lethality of the gun. The ban also forbids the use in semi-automatic guns, guns that fire one bullet per trigger pull, of magazines capable of holding more than 10 bullets. Critics say restricting magazine capacity is arbitrary because loading multiple small magazines is only nominally more difficult than using one high-capacity magazine. That is why the state of California mandates that semi-automatic rifles sold there have fixed magazines with a capacity of 10 rounds or less, which can only be removed using a special tool. Critics say the fixed magazine restriction is pointless as a determined criminal can convert a gun to accept interchangeable large-capacity magazines. Access to fully automatic guns as opposed to semi-automatic guns was not debated in the challenge to Highland Park's gun ban. The Federal Firearm Owners Protection Act of 1986 makes obtaining fully automatic weapons prohibitively expensive and cumbersome for the vast majority of Americans. By declining to hear the challenge, the Supreme Court has tacitly allowed Highland Park's ban to stay in place. A similar challenge to the gun ban in place in Cook County, Illinois, is pending in the Illinois Supreme Court.